Well, good evening, everyone. I'm Professor Michelle Foster and I'm the Dean of the Melbourne Law School. And I'd like to offer a very warm welcome to Melbourne Law School this evening to the 2025 Francis Gurry Lecture on Intellectual Property. I'd like to begin this evening by acknowledging that we're gathering on the unceded lands of the Wurundjeri people of the Kulin Nation. And I pay my respects to elders past, present and emerging, and extend that respect to all Indigenous colleagues joining us this evening. And I also just want to take the opportunity to acknowledge what an historic moment it is in Victoria with the passage recently of the statewide Treaty Act of 2025. Well, the Francis Gurry Lecture Series was established by the Institute of Patent and Trademark Attorneys of Australia with Melbourne Law School in 2009 and is named in honour of Dr. Francis Gurry, former Director General of the World Intellectual Property Organisation and distinguished alumnus of the Melbourne Law School. It's a long-running public lecture series that has offered speakers of exceptional quality a platform to address contemporary issues across the intellectual property landscape. I'd like to sincerely thank and recognise the sponsors of tonight's lecture and welcome any members of these organisations in the room with us or indeed watching online. And they are IP Australia, AIPPI Australia, the Intellectual Property Society of Australia and New Zealand, and the Licensing Executives Society of Australia and New Zealand. These organisations have provided long-standing partnership and financial support to this important and highly successful lecture series. And it's really an honour to celebrate tonight this industry collaboration and commitment to the public discussion of pressing intellectual property matters. I'd like to particularly welcome the President of our collaborating partner, the Institute of Patent and Trademark Attorneys Australia, Dr. John Landals, who will be offering a vote of thanks to close this evening. Tonight's event is the second of this lecture's three-night appearance, following Monday's visit to Sydney and tomorrow's visit to Auckland, New Zealand. Shortly, I'm going to hand over to my colleague, Professor Andrew Christie, who's the Melbourne Law School Chair of Intellectual Property, who will introduce our guest speaker. But first, just a couple of reminders. Tonight's lecture is being recorded and will be available on the website shortly, but also to confirm that there will be an opportunity for those both in person and online to ask questions of our wonderful speaker at the conclusion of the presentation. And as you can see, we're going very high tech. We have a QR code here, which you can access via your phone, and feel free to start putting questions through throughout the presentation. But now it leaves me to hand over to my colleague, Professor Andrew Christie, who is going to introduce the speaker and also run the Q&A at the end. So thank you, Andrew, and hopefully you enjoy tonight.
Thank you very much, Dean. And before I do that introduction, can I just add my very warm welcome and my very sincere thanks to all of you. And by all of you, I mean all of you in the room, and it's a full house here, and there's a very large number of people online as well. So to those online in the room, thank you for coming, because the most important and valuable thing you can give us is your attendance, your engagement, and we will allow time at the end for your engagement with our speaker tonight. I wish I didn't have to say it, but I do have to acknowledge it's crazy times. It's crazy times politically. Established truths like global warming is contributed to by humankind and global warming runs the risk of decimating humankind, we're being told by a leader of a major country, is the greatest con job ever. What do these crazy times mean for the stuff that you and I do on a daily basis? Help clients acquire IP rights, run the IP rights system, generate the innovation to which IP rights applies. Are we having to revisit what I thought were established truths about what we do? I thought the established truth of the IP rights system was that it's a major contributor to the innovation ecosystem, and it's a major contributor because what it does is it incentivises those in our society who are innovative and creative, incentivises them to do what we want, which is innovate and create, but it also at the same time, through its balancing mechanisms, maximises the return to society and the ability to take advantage of those innovations and creations. Well, I'm sure our speaker tonight will address a question like that, as well as many others, in her presentation. And we're really pleased to have Kathi Vidal speaking to us tonight. She's a very unusual and a very impressive character. She spent her childhood growing up on military bases, not just in the US, but also in Panama, Germany, the Azores Islands, a Portuguese territory. It was clear to many people from early on how talented she was. She was admitted to Binghamton University at the age of 16 to undertake her Bachelor of Electrical Engineering. And even before graduating, she was employed with GE Aerospace, now Lockheed Martin. And amongst other things in her work, she was involved in designing some of the first AI systems that were used in aircrafts. She continued her electrical engineering studies by undertaking a Master of Electrical Engineering at Syracuse University in its night program. But then she recognised both the significance of innovation and the importance of intellectual property law to innovation, and decided to commit her career to IP law. We're very glad she did. She put herself through law school, and such a distinguished school, no less than University of Pennsylvania, where she did her JD. After graduating, she clerked for Judge Scholl of the US Court of Appeals of the Federal Circuit, worked in very well-known and very respected IP firms, Fish & Richardson, and later Winston & Strawn. And in that latter firm, she became a member of the firm's executive committee, as well as the managing partner of the firm's Silicon Valley office. In April 2022, she was appointed as the director of the USPTO. She resigned that position in December 2024. During the time that she was the director, she managed one of the world's largest and arguably the world's most important IP office, the USPTO, which has, and the numbers are phenomenal to me, staff of more than 13,000 and a budget of more than $4 billion US. But she didn't just manage the organisation, she truly led it, and she committed her leadership to a couple of key aspects, and we'll hear about that tonight. In particular, impactful innovation and entrepreneurship policy. So I can't think of anyone better to talk with us tonight about the topic that we're going to address. All I need to do is ask you to join me in welcoming to the podium to deliver the 17th Francis Gurry Lecture on Intellectual Property on the topic, Unlocking Innovation, Balancing Protection and Access, Miss Kathi Vidal.
Thank you all, and thank you for showing up today and for caring about our intellectual property system. I also love that you always give homage to the Indigenous peoples and to the land when you start. I feel like the experiences I've had in other countries around the world really teach me more about how we can be better as well. So in 2021, I received an email from the White House saying, "Can we talk?" And when I received that email, I started thinking about what serving in the USPTO would look like, and if it's something that I wanted to do when I had a very successful career and was really enjoying my life in California. And at the time, I thought about issues that I saw. I thought about the privateering that I saw, where individuals will amass patents and then exert attacks on large institutions, on startups. I thought about the way innovation could be democratized, that we could bring more people into the innovation economy. I thought about our IP ecosystem, and that often through political shifts, politicians will go one way or the other, and they aren't listening to everyone trying to reach balance for the country, for the world. I thought about IP theft. In fact, when I was considering this position, one of my friends came over and she was wearing this beautiful Chanel hat. And I said, "That is gorgeous." And she said, "I can get you one, it's only $15. And then I thought about bringing innovation to impact. That it'd be great if we could democratize innovation, if we could get patents and have equality when it comes to patents. But if those patents just sit on a shelf, they do nothing to serve our communities or to serve our world. Through my service, I realized that I hadn't thought of everything, that there were many other topics that came to mind and that rose to the highest levels. The reticence about international solutions, SDG adoption by all countries, geopolitical shifts on the value of IP waivers and march-in rights. I could go on, but I did come up with 10 of them. So as Americans are wont to do, I came up with a top 10 list. And I'm going to count down that, well, I was going to count down, I have a different slides deck, so I will start with number 1. Reticence about international solutions because they may affect competitive positions. So certainly when I came into office, there was a big push to harmonization. But when we tried to harmonize across countries, what we notice is countries want to lean in a way that is going to help their people, sometimes at the expense of other people. We saw that prominently when it came to standard essential patents. Certainly Europe was putting out policy that really was beneficial to their car industry. It was very pro-implementer. And so I heard a lot from stakeholders that were not the implementers that we had to immediately stop this. China, very involved in wanting to set worldwide rates. UK wanting to set worldwide rates for standard essential patents. We also saw it a lot in the area of AI. Everybody wants to win the AI race. When I was in office, certainly we saw the EU AI Act come into existence. I also heard from stakeholders based on different countries around the world that those countries were leaning in a way that hurt particular stakeholders of the United States. One area that stakeholders expressed concern about was Singapore, because at the time, Singapore wanted to lead in AI innovation, but they did not have the movie industry that the United States have. They didn't have the news industries that many countries have, not to the extent that we did. So they wanted to lean in and say it's okay to train your AI behind paywalls. Now, I don't think that ever came into fruition, but this is the kind of issues that we saw. I will say on that, I'm going to make this optimistic and not just talk about issues. There's an opportunity when these countries come up with these ideas. There's an opportunity for all of us to get involved. There's an opportunity for your IP office to get involved. There's an opportunity for your ambassadors to get involved. And they only get involved when you have a voice, when you let the government know what you're perceiving and what you want to see changed. Number 2, international adoption of SDGs. So certainly, they were generally adopted by all the countries, all the participating members, all 17 of them. But as you heard in some of the opening remarks, sometimes countries go through shifts. For example, when we hosted IP5, which was the other 4 largest IP offices in the world, so that's Europe, China, Japan, and Korea, we, the United States at the time, said, what is it we can all agree on? Because we have differences of opinion when it comes to IP. And we didn't want to get there and debate and fight it out. We said, what could we all agree on? And we said, the climate. The climate is something everybody can agree needs attention. And so when we had our meetings, that is what we focused on. And as soon as the new administration took hold, that was something they didn't believe in investing the same type of energy in. So that happened now, but when I was in office, I had heard that China was adopting some of the SDGs much more rapidly than other ones that were kind of falling a little bit to the wayside. And I think those kind of challenges are happening everywhere across the globe. We can all, at a high level, generally agree with the SDGs, but we need to work together and nudge each other. Certainly, we nudged China where we saw an opportunity. I'm sure people are nudging the United States right now where they see opportunity. Number 3, IP waivers and march-in rights. This is not something I thought I would have to deal with. I had no idea when I first got that email from the White House that there was going to be a push to give out free IP to solve issues. In fact, after I said I would accept, that's when there was a push for the COVID waiver. The TRIPS waiver for COVID, where countries could waive IP rights in order to create COVID vaccines. Now, that all happened before I came into office. When I came into office, the very next thing, and you'll see this on the slides, is that in 6 months, that same group was going to take up the idea of expanding the COVID waiver into diagnostics and therapeutics. And boy, did I hear from stakeholders on that. They not only had concern about that, they said, what about the environment? Is that next? Are they going to go after electric cars? Like, where is this going to end? Because we know that the things that are developed with IP are important to the world. Where are they going to stop? So what we did on that is we forced evidence-based decision-making. So I worked across US government with our Secretary of Commerce, with the trade representative, and we had a study done in the United States on, is this really the right thing to do? And that study, as you can imagine, was inconclusive. And guess what happened? That did not get over the finish line. A lot of times, I considered our biggest wins the things that did not happen. Same thing with international treaties. In 2024, there were 2 international treaties. One you all cared very much about. That was the Genetic Resources and Traditional Knowledge. Yes, Michael is shaking his head yes. Australia cared a lot about that. It's your value system. There was that, and then there was a design law treaty. Design, patent law. Nothing in there that would suggest you needed an IP waiver. But in the first versions of both of those treaties, there was an IP waiver. An IP waiver just gratuitously put in there. So I worked with the US government, and then we worked with our colleagues across the globe to make sure that that IP waiver was removed. Same thing with the World Health Organization. After the COVID waiver, they thought, let's prepare for the next pandemic. What better way to prepare than do an advanced IP waiver? And so they had an advanced IP waiver. Now, again, we worked hard to keep that out. In terms of IP waivers and march-in rights, I talked about IP waivers, but there's another issue. And this is on a country-by-country basis. I went up and looked up your laws, Chapter 17 and Chapter 12 of the Patents Act. Michael's again nodding his head. So in the United States, we have something called Vidal. And Vidal gives the government, in certain very limited circumstances, to march in and take back the inventions where they paid funding for the inventions that were developed. During the Biden administration, I'm going to be fair, I'll talk about all administrations. During the Biden administration, the president really wanted to make sure that we had cheaper drugs for everyone. He saw what was happening around the country with insulin and other drugs where people were just, they could not afford and were not getting the drugs they needed. And so some people in the administration thought we should come up with new policies around march-in to make it easier to march in to lower drug prices. Now, of course, I had concerns about that because once you start marching in, then nobody can trust the system and nobody's going to invest in IP that might be taken away. So at the end of the day, that did not get across the finish line. Most recently with this administration, President Trump has threatened to use march-in against Harvard. Now, you have some of the same concerns here. You've got provisions in your Patent Act that would allow essentially march-in rights in a couple circumstances. So this is also something we have to keep front of mind and make sure that those are interpreted extremely narrowly, because the one time you do it, you're going to dismantle the entire system and the faith in it. Now, Francis Gurry, of course, we have to pay homage to him because this is his lecture. So I found my favorite quote from him. Favorite quote. Questions of access, equity, and justice are all legitimate and fundamental. We can all agree on that. but they do not arise until we have something to have access to. What a beautiful quote that expresses the need we have to push back. Number 4, geopolitical shifts on the value of IP. Some of these I'm going to go more quickly on because there's some I want to do a deeper dive on. But in this, there is a general thought that the global north thinks about IP differently than the global south. And that the global south is generally, and these are more least developed, less developed nations, they're not the Australias of the world. The global south is generally thought to encourage the waiver of IP. They're the ones that worked the waivers of IP in. So there's a difference on the value of IP. But again, to be optimistic, there's something we can do about it, and we're working on it all the time. Your IP office is working on it, the US IP office is working on it, and it's educating the countries around the globe on the importance of IP, that waiving IP may be a short-term solution for them in terms of economic prosperity, but it's not going to last. The way they become successful, the way they grow their communities and build is by embracing IP. Number 5, privateering. Remember, this is one of the ones that made me think maybe I should take this job. In the United States and around the world, privateering is increasing. And I just wanted to pull some stats for you and just show you visually what's happening. There is a linear curve in the amount of cases brought by people who just want private money. They're not using IP to contribute to the world. They're not building jobs. They're not building communities. And if you look at the data, the patent troll market size, and that's obviously a pejorative term, but that's a term that's used to mean not for non-practicing entities. There's maybe non-practicing entities that have a lot of value, like universities. These are people who amass patents and use them to extract a tax. The market size was valued at US $5.64 billion in 2024 and is projected to reach $9.26 billion by 2032. And the litigation funding is on the rise too. You want to bring one of these cases, the money is going to be there for you because those litigation funders are also taking a cut. But again, what can we do about this? We as individuals, we as citizens, I mean, that's all I am now. We have a voice. I filed amicus briefs. I get involved in policy. I get out there and speak about what I think is emboldening this activity. And we've got to keep that voice. Number 6, balancing the IP ecosystem. This is another thing I spent a lot of time on. Remember, that's another thing that I thought, hey, if I got this job, there's work to be done. When I first got into the USPTO, I worked with our Department of Justice and NIST, our Science and Technology Division, and we withdrew the US's 2019 Standard Essential Patent Policy. Why did we withdraw it? Because we heard from other countries and from stakeholders that it was emboldening countries that had self-interest and it was not actually serving our people. And the US started these policies. We started one in 2013, and then we came up with a new one in 2019. Then we emboldened other people to come up with these policies, and we thought, look, we got to just stop this madness. In addition to that, I worked closely with the FDA, our Food and Drug Administration, because drugs are a hot topic. I wanted to work with them to say, let's make better IP. Let's create stronger IP and not weaken your IP. And let's make sure it's not used to extend monopolies beyond what the patent system envisions. I worked with our seed industry, USDA, because a lot of the family farmers throughout the United States were having issues because the big monopolies would own patents and then would own patents that you couldn't possibly farm in the United States without somehow infringing those patents. And then you had to take a license, but then that license was on these really unreasonable terms. And then this got more press than most anything. I don't know why, but we have an agency or a portion of the agency that reviews patents a second time. So if we issue a patent and it is not valid, you could, at the time, take that back to our Patent Trial and Appeal Board. And they would look at it anew. Now, when I got into office, the administration before me put forth a bunch of factors and said, if the USPTO does not want to look at your patent, or whatever the patent is that's before it, it can weigh these factors and not look at it. And the problem with that is when you have a whole bunch of factors, judges can interpret them differently. There were concerns that there was going to be political influence or that there was political influence and that we were emboldening patent assertion entities and hurting US companies. And so what I did was I came out with what now that it's been withdrawn, is referred to as the Vidal memo. And that memo tried to create certainty and take it out of the hands of the politicals and say, we need to come up with rules on this that everybody can understand and that are applied fairly. And it came up with what I called at the time, with the help of my colleagues, the substantial merits test. So yes, maybe there are some instances where it makes sense for the PTO not to take a second look. But I felt it was incumbent on the PTO to take a second look if the patent is invalid. If we knew that there was substantial merit to that invalidity challenge, we didn't want that patent out there causing ruckus and causing companies to have to pay money. 7, IP in the age of AI was not a thing when I came into office. This is pre-ChatGPT. ChatGPT came out. The very first thing I did was I called our CIO and I said, I need you to send a note to the entire agency right now. And he said, should that note say no ChatGPT? And I said, no, it should say not yet. Not yet. We want to embrace AI. We want to make sure that people are innovating with it, both in the agency and outside the agency, but we need to make sure that it's safe. So in the age of AI, we've had to rethink a lot of things. I issued guidance when it came to AI used in the inventive process. And in that, it was always about striking a balance. And I'm going to have to cite to Michael's little project of going in the back room and making every chair. This is Michael who leads your IP office, Australia IP. He had told me a story about going in the back room and designing every chair with AI. And I thought, how interesting. Now, what if a company or a person who wanted to make a lot of money did that and then patented all of them? Wouldn't that be clever? And so when we came up with the policy, we said, there's got to be a human in the loop. There has to be some human investment. And it was not only to prevent that opportunistic or pioneering behavior, it was because of what's going to be my last topic, because we need to bring that innovation to impact. And if you just create a whole bunch of patents that block other people and you're not investing in some way, you're not creating jobs, you're not creating solutions. And then, of course, artificial intelligence. I worked very heavily with the Copyright Office. I was the presidential advisor on copyright. The Copyright Office is the one that grants the copyright. So we worked on a lot of different policy. And we put out requests for comments. There's a lot in this area that needs to be fixed. Not fixed because it was broken from the get-go, but fixed because in light of AI, there are new issues that have arisen that our laws cannot deal with. So again, it's an opportunity for all of us to get involved and to shape the future. IP theft, Chanel hat, you got that one. So we created a McGruff the Crime Dog advertising campaign. We ported it to Mexico. They don't like dogs, they moved it to an iguana. But it was still effective, it was still effective. One thing that we did a lot on counterfeiting. We did a lot with countries where they weren't enforcing IP rights. We brought the judges in and taught them. And they said, oh, you can issue a temporary restraining order for this? And we had our judges say, yes, we do it all the time. Let us show you how. And one of the things I'm most proud of is we know that the small to medium-sized enterprises have their IP stolen all the time by one country in particular, I won't name names, where people come in and will say, I'll give you some money, give me a pitch. They have no interest in giving money, they walk out with the IP. Or they say that and they invest a little bit and they walk out with the IP that they actually now own. Or they engage in cyber crimes. And so I worked with our FBI and we created a whole program for startups because they can't be NIST compliant, like the highest level of compliance when it comes to cybersecurity. But we need to keep our technologies, especially from the most vulnerable, the small to medium enterprises, safe. Number 9, democratizing and unleashing innovation. I'm going to speed up my pace of talk because I've got a lot to get through here and a lot of enthusiasm about this. The numbers are abysmal. We know that. This is my little flag. This is the US numbers. Australia may be a little different. Women, patent ownership, 13%. Business ownership, 22%. Black Americans, a big portion of our society, patent ownership, 1%. Business ownership, 2.5%. I could go on, but I'm optimistic because when we got out there and really doubled down on free legal services to people who couldn't afford it, the participation rates, 43% of participants were women. 35% were Black Americans. 16% were Hispanic Americans. Native Americans who didn't even show up on that other one, 1.5% came from them. So there's innovation everywhere. We just need to get out there. We need to meet people where they are. So that's what we did. Not only did we meet people where they are, but we created the first ever national inclusive innovation strategy. It's not on the internet anymore, but I will post it. I posted it on my LinkedIn account, and I'll post it again because there are a lot of great ideas that everybody can adopt. Great ideas I spoke to countries around the world about when I was in the position. We started with our children. The last year I was in office, we trained 380,000 children across the United States on IP and innovation. I love this picture of Grace. I met her in Utah, and she was designing something, and it was related to some show about singers. If I were more hip, I would know that show. Do not remember what it was. But she was designing it, but she was using electrical engineering and other concepts to design this. And I said, what do you want to be when you grow up, Grace? And Grace said, you know, I used to want to be a singer, but now, maybe an engineer. Amazing. People who come out of this program, when we reach our children, are more likely to stay engaged in school, they're more likely to complete school, they're more likely to go on to college, and they're more likely to go on in the STEM fields. Really positive things. And then we said we need to reach everyone. So we went out and got into our libraries. Librarians are very, very skilled. And with the internet, they're underutilized. So we said, why don't we teach librarians how to offer our services? So you can go to your local library and get those services. We also, in terms of meeting people where they are, it wasn't just geographical when it came to libraries. It was how they communicate, how they identify. We knew that if we threw an event for women, women would show up at much higher rates than if we threw a general event. And we always said everyone's welcome. Even the women events, 10 to 20% of the attendees were men. We focused on Black innovation. We focused on our Native American community who looked at IP in a different ways with a different value system. We wanted to make sure we were embracing the way they saw it. We focused on our military. And then we looked for barriers. So this woman here is one of the only 40 women African-American patentees in the United States history. Crazy. I met her at a conference when I first started. We were sitting in chairs like these, and she was telling her story. And she was telling me that when she got that first substantive communication from our office, which by the way is a rejection, she felt rejected. Crazy. But she was saying how she had a lawyer who helped her through that. And then I thought after that, I wonder if more women than men opt out when they're rejected. So I asked our team to go figure that out. Go look at the opt-out rates. And true enough, women opted out at a much higher rate than men. And to me, that was a surrogate, not just for women, for people with different backgrounds, or introverts, or people who don't have as much money. I mean, who knows how we identify ourselves? But anytime you see a disparity, to me, it's bigger than the one that you see. So what we did is, even before you get that rejection, we offered this letter. Welcome to the system. You can now use patent pending. We created an IP identifier. Maybe there's some other IP that you have. Go check that out. You might need a trademark. And we gave them all of the resources. I believe this is the current version. Ours actually had a picture of me, and our deputy director, who was a black male, because we wanted people to see themselves in us. Then we offered a second letter. Actually, I reverse these. This is the first letter. Then we offered the second letter. So when they got that rejection, we put it into perspective. We're here to help. Need a lawyer? Go see our pro bono lawyers. So we wanted to make sure that people had the support that they needed. In addition to that, it's not just about the programs, it's about listening. For the genetic and traditional knowledge, we listened to our tribal nations. They came to Geneva with us. When we shaped policy, we need to listen to everyone, not just roll out programs for them, so that's what we did. The other thing we did, which I think is terribly important, is to work across government and identify any barriers to innovation. Because people who don't practice in the IP space, who don't focus day in and day out on innovation, may not realize how their policies are going to impact innovation. And I'll just give you one example, which is ironic because we've got some policies in the United States right now on immigration. Ironically, in January, the beginning of this administration, they published a report that we created that showed that in 2012, immigrant inventor patentees contributed to 40% of all domestic patents. And since patenting is a surrogate for innovation, that just shows the important role they play in our country. So when I was in government, I would spot things like this, and then I would go talk to the White House and others to say, let me tell you how I'm seeing this so that we can come up with a solution that does not harm innovation and in fact promotes it. Number 10, told you it was a top 10, so last one. We gotta bring the innovation to impact. We have to bring it to impact. Climate, there are so many climate innovations out there. I was in Brazil and I was on a stage like this. And right before I came on stage, they were celebrating some Brazilians who had come up with this system of using a cigarette butt, apparently lots of them, to filter impurities out of the atmosphere. And I thought, that's interesting. Where else did you patent it besides Brazil? And I thought, well, that's too bad. Because if you didn't patent it, nobody's going to invest in it. Nobody's going to actually get that to market. So we need to make sure that we're not just creating patents and putting them on a shelf and then waiting for some privateer to come get them and try and monetize them. We need to make sure that we're bringing them to market. IP Australia recognizes this. 3 quotes on the value of patents and the value of trademarks to companies. We also, in addition to coming up with the first ever inclusive innovation strategy, we also came up with the first ever entrepreneurship strategy. The US is applauded for being one of the best venture capital communities in the world, but we don't have it right. Not enough people are participating. We still have barriers. So I worked with the Commerce Department and the Secretary of Commerce, and we came up with a strategy. This one is still online if you want to look at the strategy. So as I mentioned 10 challenges, but there's so much opportunity. There's opportunity for you to get involved, and there's opportunity for you to make a difference. So thank you. Showing up here today, showing up to events like this, talking to your colleagues about the issues that we've discussed is a first step to making the world a better place through strong intellectual property. I appreciate you.
Thank you very much, Kathi. That was fantastic. A tour de force, I think, is the phrase. Cliched as is, but very true with this one. And that call to action has excited me, and I'm sure excited everyone in the room and online. Let's take the questions, and remember, in the room too, use the Slido QR code. You'll get to a very simple location which will allow you to put your question in. You can be anonymous, or you can give me your name. If you give me the name, I'll name you. If you leave it anonymous, of course, I can't. So you've got the choice. I'll start with actually the first question we got, and you sort of finished with it and also mentioned it in passing. So it's a big question. I'll allow you to take it as a way to say anything further on this particular issue that you would like. This is from Anonymous, And it is phrased as follows: why is the US miles ahead in innovation compared to other countries? And then there's a sort of follow-up, but you could take that as the key question. Is it due to institutions or due to attracting outlier talent from around the world? And in a sense, what this question is really asking you to do is to comment, but we in the audience in Australia are particularly keen to see what insight you might add on that one, Kathi.
Well, I appreciate that. And as I mentioned, we are to some extent the envy of the world when it comes to venture capital. Every country that I went to wanted to know what our secret sauce was and how they could help import it. Some countries would start their startup work and then go to the US for VC capital. And a lot of that has to do with our culture and how we've kind of grown up as a nation, that pioneer, that cowboy, cowgirl spirit, and the willingness of the private sector to invest. I will say that a lot of the investment that we get from the private sector follows government money. So that's another thing I would feel strongly about, is any cuts in terms of government money for research and development doesn't just impact that government money, it impacts the influx from the private sector as well. So that's one. Another one that people will quote when they're comparing us to Europe is that we don't overregulate. Now, I'm sure Europe is saying we underregulate, and we say they overregulate. But I just had a conversation with the Parliament, the European Parliament, a number of their members, and they were expressing that Europe wants to be more independent and not rely on the US as much anymore on innovation. And they were asking me, what should we do about the fact that we're want to overregulate, especially on AI, which is a very important area. A lot of their regulations, I work for a large language model developer right now, and they're difficult. It's difficult to interpret them. They're expansive. It appears sometimes that the regulators don't fully understand the technology and what's possible. But I would say, to me, those stand out. And for the third one, the immigrants. I mean, we are a country where people come for opportunity. And when they come for opportunity, they're hungry, they're excited, they are hired by great companies, they collaborate, and as you saw from the statistics, they contribute.
Yeah, three great lessons for all countries, and that statistic stood out as phenomenal, actually. Thank you very much for elaborating on that. A question from Mark Summerfield. People who advocate for balance in the IP system have been criticised in the US as being anti-patent. The Patent Trial and Appeals Board in particular has been called a patent killer. How politicised is the US IP system, and how much pushback did you experience?
100% politicized. So the issue with balance is everybody uses it, and you can use it in any which way you can, you could say whatever you're doing is balance, right? So the idea of patent killer, it's not. Like, we did the data. Our USPTO PTAB invalidates at the same rates as district courts. And people were pushing to say, oh, this is so unfair, we need to go to district court. The numbers were manipulated. So what they would do is they wouldn't look at the institution. They would say, okay, once it's instituted, then you have a higher likelihood that the patent's going to be invalidated. Of course, because we've already made the determination that you've got a weaker patent that we need to take a look at. So instead of doing the numbers from the beginning, those numbers can be manipulated. In terms of the PTAB being called a patent killer, that was many, many years ago when it was called that. I've not heard that term anytime recently, but I do know that there are a couple of groups that do believe that the PTAB should not exist. I mean, you're seeing it play out right now in US government. For whatever reason, they don't believe that that should be a viable mechanism, even though it was put into place by our Congress. And the only thing I would say to that is, if I look at the behavior that's happening, it's emboldening the patent trolls. They are now out there in droves and trying to act quickly while government is very favorable to them.
Thank you. From Anonymous, fraudulent and criminal actors, including those involved with fake invoices, register entries and scam solicitations, things that Australia has seen as well, not just the US, other offices as well. Those activities pose an increasing, pose an increasing global IP issue, a threat to the integrity of the IP registers, for example. How has the USPTO addressed this, and what more can be done, not just by the USPTO, but internationally for all offices?
So we did issue a request for information to find out how we could do better. We engaged a lot with the online marketplaces to encourage them to come up with better procedures for takedown, because a lot of times that's the best and easiest mechanism. We worked a lot with the FBI. Unfortunately, the counterfeiters get smart and they start moving things in smaller batches, and it's very difficult for some of that to be detected. I know that with blockchain and with AI, we were thinking about how we might get more creative. I think there's a lot of opportunity for the world to get more creative in terms of ensuring that the right products are purchased. I will say, in addition to the Chanel hat, and by the way, that person owns like islands. This person did not need to buy a $15 Chanel hat. But you know, in terms of our culture, the other thing that happened right after I came into office is there were a bunch of really rich women in New York who were bragging about the fact that their husbands are happy that they're not buying real Prada bags and that they're saving the family money. I walked that into the Secretary of Commerce. I'm like, you have to look at this. We have to do something about this. So part of it's cultural, which is why we did campaigns to try and change the way people think, to make them realize these are benefiting criminal institutions. I mean, these are crime syndicates that you're enabling that are hurting your children. These products are inferior. Houses have burned down. Airbags, not one counterfeit airbag, according to the evidence that I've seen, has saved a life. Instead, they kill. They either underdeploy or overdeploy. So we tried to get that out there. And then what we did was I went on news stations around the country at Christmas, right before Christmas, to say, buy real. Like, take care of your families, buy real this Christmas. So we tried to do what we could. A whole lot more needs to happen.
Okay, thank you. You won't be surprised to know that many of the questions that are coming in are dealing with AI, and I'm trying to find the right balance between some that are very specific, including on copyright, and you're welcome to talk about that because you mentioned you were advising on copyright, even though we don't associate copyright as being within the USPTO's bailiwick. But I'll put this one, maybe I'll put two to you that are rather general in nature, and you deal with them as you see fit. One from Anonymous is, what do you see for the future of AI use in the inventive process under the Trump administration? So a question about under the new administration, what do you see for the future of AI and its utilisation in innovation creation?
So I do think the Trump administration is very pro-AI, which I think is very, very positive for our country. The last administration was also pro-AI. We don't want people to fear it. We want people to use it. We want them to use it in the inventive process. And I will say, though, a lot of the work that I did was taken down, the work on inclusive innovation, the Vidal memo. The guidance on inventorship has stayed in place. So I'm guessing there was a deliberate decision made on that because they did go through everything. So I'm hoping that they embrace something like that. It doesn't have to be identical, but something that encourages people to use AI in the innovative process and just make sure that we're not locking it up by allowing somebody to go in their back room and create every chair.
Thank you. Another anonymous one, patenting is not cheap and startups and SMEs are often faced with resource constraints in terms of allocating a budget to IP. Money is a major barrier to people getting patents. Question, how can we overcome this better to enable access?
So a couple things. One, I love the pro bono concept. People worry about the fees to the patent office, but most of the money goes for paying lawyers to get you a good patent. And so I think the more you can develop a culture where more people contribute their time in that process, the better. We also in the US have different pricing depending upon the size of the entity. So I think that helps. In addition, I did go out in communities and ask what more we can do. We spend a whole lot of time on innovation, a whole lot of time on entrepreneurship. And we heard from people, entrepreneurs, that they would prefer to go more slowly in the process. So we had a fast track And I was like, well, maybe we need a slow track because they said, we don't yet have investment. Like we don't want to spend the money fast. Like we would rather just have the patent application pending and not incur the expenses. And so we did investigate a track 3, like the slow track. And when I did that, I realized there's 2 opportunities to pause your application. So we just needed to get the word out because sophisticated companies were doing this. For applications they didn't care as much about, they would pause it twice for 6 months each. So we got the word out to entrepreneurs about that. The other thing is the provisional application, more people need to know about that. It's less than $50 to get one on file. And it buys you that year, not only to decide whether you make the expense based on your testing of the market, your testing of the product, but it also then delays any of the other costs. So it really, for us, was a lot about education.
Okay, thank you. You expressed great interest in recognition of Indigenous peoples. You made reference to our Indigenous peoples in Australia and Indigenous peoples in North America. This question connects, I think, to that. Let me ask it. It's from my colleague, Ben Hopper. The initiatives discussed are highly laudable, but do policymakers and influencers also need to focus on legal recognition of non-Western ways of valuing and protecting new knowledge? So a question really to what all of us have to think about is there are non-Western Indigenous knowledge systems, etc. To what extent are policymakers, do you think, in the US recognising that, and what would you say to policymakers in Australia and elsewhere on that?
So I think in the US, it's difficult given that you're in the administration for 4 years at most, because every president gets to pick their new director of the PTO. We did engage a lot with the Indigenous people in the United States and asked them about this and really worked with them on what kind of system do we need that respects your values? Because what we heard from them is the traditional IP system, patenting where you're excluding others from using it, was not symbiotic with how they saw the world. And so we asked, like some of the leaders would talk to us about maybe just repackaging some of it as community. You don't have to own it yourself. If it's all about the community, you could either file for it and then make sure the community has all of the access, and that there's other ways to deal with it. But to your point, there are other systems. I know when we were working on that treaty, we all learned a lot about the values of our Indigenous people and the differences that those other systems make. I think a lot more can be done on it. I will say our administration was very forward when it came to this work. We learned those things because when we start engaging and then people say, oh my gosh, nobody's ever even brought us into this. So I think as a country, we need to get better across administrations to listening and to making sure that we're considering all that as we shape the IP of the future. Because it's going to need reshaping with AI, and what a perfect time to rethink it from scratch.
Thank you. Very impressive. Quite a specific question, but a very important one, as you will know as soon as I read it. Do you agree with Trump's view that drugs...
No. Oh, wait. Just kidding. Just kidding.
Do you agree with Trump's view that drugs in use are too expensive? Do you think the solution lies in the IP systems? A very important question about
yes, no.
Price and
yes, no. They are too expensive. I mean, the cost of drugs in the US are outrageous if you don't have the right insurance. They're not that way in the rest of the world, and I think something needs to be done about that while listening to the pharmaceutical industry. We can't go off in a vacuum and try and solve for this without our key stakeholders who are actually creating those drugs. It gets back to Francis Gurry's quote that I quoted. You need something to have access to, right? So we need to bring them in the loop. That's what we did with the FDA. We didn't just go off and say, we're going to come up with our own ideas in a bubble. We engaged with the FDA and we engaged with the pharmaceutical industry and we changed things, but we changed them more at the margins and didn't just say, we're going to waive IP or do something like that would have dramatic effects on even having something to have access to.
Mm-hmm. Thank you. And I'm going to ask this follow-on one, which relates to pharmaceuticals and very specific and back to AI. AI is increasingly being used to identify first-in-class drugs, where inventive step is in finding the needle in the haystack. How could IP laws be reformed to encourage that kind of innovation without the perils of recognising AI inventorship?
So that's what we had envisioned. So if you're finding that, I really don't think that you're just setting AI loose on the internet and saying, I want to find the best solutions to all the worst human problems with disease, and it's just returning an answer and boom, you have it. Really what you're doing is you are inventing with AI as a tool. You're doing prompt engineering, you're re-prompting. And so what we were recognizing is, yeah, we don't want somebody just to set something out on the internet and not actually have an inventive contribution, but you can have an inventive contribution through your use of AI, and we want people to do that. So that's what we were protecting. I will say that I did convene G7 to have discussions about this, because I think we solve for this the right way. Let's start internationally. Like usually we start with some bubble, whatever that looks like. You all start with the Vancouver group. I know I was not invited into that. That's like Canada, UK, Australia. But we all start with some initial outreach, and then we move on. So we started with G7, and there were concerns. Like they thought a lot of this should play out in the court system. And I thought it'd be better if the IP organizations who know better where this should land, who have the data, who've heard from stakeholders, if they could help shape it without us all just being subject to what the courts decide, I thought we could shape this in a way as opposed to having it shaped for us.
Mm-hmm. Thank you. And it's amazing how time goes quickly, and so this will be the last question. I've chosen it because it's something that we're all passionate about. You expressly acknowledge that, but we're here because we're part of the innovation ecosystem, to use that cliched phrase. We want to see more innovation, want to see more entrepreneurship. This question is from Julie Dow. Could you touch more on entrepreneurship? Can you touch more on the entrepreneurship strategy? And in particular, what do you think Australian entrepreneurs, and I would say Australian policymakers, if I can add that to it, and indeed Australian IP rights service professionals, etc., what do you think Australians can learn from it?
So we came up with 10 recommendations, and for us, it was starting with where we are right now as having a very good, strong VC system. So I think you could probably extrapolate from that on how to build that system, but you might want additional consultation. I will say there are people who are very like-minded who'd be more than happy in the VC community to have those type of open discussions about how we've shaped that in the country. When we did shape it, we had a lot of people who were from the VC community. I was an angel investor before I went into government. Secretary of Commerce was a venture capitalist before she went into government. A lot of people on the committee were in that space. And so we were trying to identify any of the barriers, including why people weren't participating at higher rates and how we could get them to participate. So one of the issues is women, as you saw from my statistics, they participated a very, very low percentage. And well, I didn't show VC funding statistics, but they're worse. They're very abysmal. And part of it is people want to invest in people that they know. They're investing in the people and not the ideas. So we worked through that, and we thought, well, patents are somewhat a democratizer of innovation. So if a woman comes in and wants money and she has a patent, at least there's something there, even if she doesn't have the past experience with that venture capitalist. We also saw things across government that we felt like we could do better with. Maybe there's some taxes in the beginning that we didn't think venture should have to pay for as they were starting to build. So I would encourage you to read it. It is, you could ping me if you can't find it, but that one is still live. And I'll repost that as well on my LinkedIn page. And like I said, I'll post the Council for Inclusive Innovation, which I think they tie in really well together if you look at the recommendations. And thank you for caring and asking that question.
Thank you. Yes, well, indeed. I'm going to call in a moment on Dr. John Landell's President of VIPTA to bring tonight's proceedings to a close, but I note that Kathy's so generous with her time that she will be here after the formal closure, and you will be inundated with people coming up to talk to you, Kathi. I'll have to drag you away for dinner, but she will be here for a few minutes afterwards. So if there were questions that you've only just thought of or didn't get to answer, or that I didn't get to ask on your behalf, take the advantage of speaking with Kathi. But we have come to the time that we said we would bring the proceedings to a close, so I asked John Landells to say a few words to do that.
Hi, on behalf of Vidal, I'd like to thank Kathi for such a wonderful presentation. It's been really interesting hearing about your impact and projects at the USPTO. We're really thrilled that you took the time to come down under to Sydney and Melbourne, and the next leg of your trip to my homeland, Aotearoa, New Zealand. I'd also like to thank the Melbourne Law School, and in particular Andrew Christie, who's made, has done all the heavy lifting to make today's event so successful. I'd also like to thank the sponsors, AIPPI Australia, IPSANS, LESANS, and also IP Australia. IP Australia not just for the sponsorship, but for attending in Sydney and Melbourne. So Michael, Margaret, Charlotte, and Christina, and probably a few others here today. And last but not least, all of you, thank you for making it so successful, both those here today and also those online. So I'd like to sort of thank Kathi again. Thank you.